Okay, so I think we can start now. And um,
I'm just saying that I need to share the PPT. I've shared it with you. So would you be doing it from your end or should I be doing it from my end?
you can run it from your end.
Okay,
Uh,
can you share screen? This thing as well.
yes, there. Okay, right. So we can quickly start with the session now.
Sure.
And so I'll just extend a warm welcome to all our participants today. I'm Bijetri Roy, and this is EBC Learning's webinar on attachment, adjudication, and confiscation of property under the Prevention of Money Laundering Act. So, for those who are not aware, EBC Learning is the educational initiative of EBC, and our objectives of EBC are to help remove hurdles from legal education, empower people to make life-changing moves, and more importantly, to help you learn and win. Now, as you can see, this session is live and is also simultaneously live on our YouTube channel, which is EBC Learning. Now, before we start, I'll just briefly tell our participants that we will have a Q&A session towards the end of the initial discussion. So I would suggest that you all please write your questions in the chat tab, which is located at the bottom of your player. And before we begin with our session today, I would like to introduce our guest, Pallavi Pratap. Welcome to EBC Learning, Pallavi.
Thank you, Bijetri, for having me here. It's really exciting to be here, finally talking to you again.
Yes. And so basically, I'll just briefly tell everyone who is Pallavi. Pallavi is an advocate on record, Supreme Court of India, and she is the managing partner of Pratap and Company, which is a full service law firm in Delhi. She has advised clients on a wide range of matters, including IPR, trade remedies, ADR, including international and domestic arbitration, commercial litigation, insolvency, and bankruptcy litigation, among other matters that she does from time to time. Now, the topic for today, the Prevention of Money Laundering Act, which we generally call PMLA, it was enacted to prevent the menace of money laundering and to provide for confiscation of property which has been derived from this kind of money laundering. Now, there is a separate process for trial of the offense of money laundering, which I'm sure Pallavi is going to explain as well. The entire procedure for the property involved in money laundering has been provided in the PMLA itself. So, Pallavi, there are some of these common terms which we generally come across with respect to PMLA. So, the three of them that you've already used in our in the name of the topic as well: attachment, adjudication, and confiscation. So, if you could start by explaining these terms first, and then probably explain the legal position, and then the cases in this regard. Also, like we discussed earlier, I was asking you about case that I came across, the JSW Steel's case, the NCLAT case. So, towards the end of your discussion, if you could probably also give us a brief view on the JSW Steels versus Mahindra Kumar Khandelwal judgment. And for all our participants, please start writing your questions in the Q&A tab so that towards the end of the lecture, I can read out the questions and Pallavi can answer your questions. And towards the end of today's session, I'll just take a few minutes of everyone's time and I'll give you a virtual tour of our website, EBC Learning. So now, Pallavi, you can start with your presentation.
Thank you so much, Bijetri. I think it's a very interesting topic that you gave me. I think PMLA, with the kind of the cases which are going on just now in the country, we see that there is a lot of relevance of this just now, and also anybody who intends to practice, before the PMLA adjudicating authority, or as far as prosecution is concerned, before the concerned special courts. I think it is important for all of us to also know what is Prevention of Money Laundering Act. Even though the act has been around for nearly 20 years now, and we have seen various amendments which have happened to the PMLA Act. We've also seen the evolution that has happened as far as the act was concerned. And there's a very small, actually, a presentation that I thought that I will give so that quickly everyone can get refreshed to exactly what we will be talking about. There are specific questions that you've asked me about defining, attachment, confiscation, and of course adjudication. So I intend to cover those specific parts as far as my presentation is concerned. So I'll just start with the screen share. If I can be enabled to share my screen, please. Thank you. I'll just start 1 second. So are you able to see the screen share, Bijitri?
Yeah, Pallavi. I can.
All right, wonderful. So I will actually just get started with what exactly is, anti-money laundering, or AML as we call it, and what was the intention of PMLA in terms of why was it introduced, and what was the reason for bringing about PMLA. And that was primarily to prevent money laundering, which was happening across the country, and not just locally, but we've seen it, a lot of money laundering which is happening internationally. For instance, if we look at some specific cases, for instance the Yes Bank case, or different other cases which are tagged along, you would see that because of some money laundering that took place in Brazil, for instance, the assets of companies in India are getting attached as a result of some money laundering which took place in Brazil. And that is primarily because this money laundering web is so spread across that it is very difficult to ascertain as to where this is taking place, and also to ascertain who are the culprits just now who are involved in such a case. So now, coming to Prevention of Money Laundering Act, PMLA was enacted to prevent the menace of money laundering and to provide for confiscation of property derived from or involved in money laundering. So this is primarily the intention which was there. Now, very interestingly, why was it that money laundering came into being, and how is it that you differentiate any attachment that is taking place? So, coming to money laundering specifically, whosoever directly or indirectly attempts to indulge, or knowingly assists, or knowingly is a party, or is actually involved in any process or activity connected to proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, shall be guilty of offense of money laundering. So, coming to your first question, where you were saying what is attachment, and if I have to define it, how is it that I will define it? Attachment, as per the PMLA Act, is given as, if you would read it, it's in definitions section 2(1)(d), where it says attachment means prohibition of transfer, conversion, disposition, or movement of property by an order issued under Chapter 3. But what is it that is going to be attached? What is going to be attached is the property which has been brought, or any asset which has been brought as a result of proceeds of money laundering. So let's say an ex person receives some sort of money in their account, which is as a result of money laundering, and he or she invests it into a specific asset. Then that asset will be considered to be bought as a result of the proceeds of money laundering, or proceeds of this crime, and that specific asset will then be attached or confiscated, because it will be considered to be as a result of the proceeds of the crime, which is the money laundering. Now, what is attachment under PMLA? PMLA provides separate provisions relating to attachment and confiscation of property that may be involved in money laundering, and a separate procedure for the trial of the offense of money laundering. Now, here, if you look at this definition, you come also to the definition as far as adjudication is concerned. Now, PMLE is a very interesting act where you would see that just like you have, there were specific special provisions or special enactments which took place on similar lines. I mean, for instance, if you look at Income Tax Act, or if you look at something like, the NDPS Act or the Customs Act. Now, there is something called as, the part where adjudication takes place, which is a quasi judicial authority. But when you look at the prosecution, there are special courts which are made for prosecution. So this is where the difference lies. Typically, when you look at any offense that takes place, there is normally something which is called as, you go to the court, and that the entire adjudication and prosecution takes place in the court only. But here, separate authorities have been created. There is an authority which is going to only look into the adjudication aspect of it, and then there are special courts which are only going to look into the prosecution part of it. So this is the differentiation that, Bijetri, we were talking about the other day. This is why this special enactment actually comes in handy. So coming to PMLA, attachment, like I said, would always be, or confiscation will always be of property, which is as a result of the proceeds of crime. And that adjudication will be twofold. One is the adjudication part of it through the adjudicating authority, and the other one is the prosecution part of it through special courts. Now let's come to provisional attachment. This is something which is, a lot of times we consider this to be a boon and bane kind of a situation, because PMLA, of course, has been given extensive rights. Now, these extensive rights also, I'm sure, bring with them a lot of responsibility, which unfortunately we do not see when you are practicing, in the PMLA adjudicating authority. You will see a lot of times that these provisional attachments that happen are done blindly. So, for instance, there is something called as a term which is reason to believe. Now, if the director or a deputy director has reasons to believe that this particular property is as a result of the proceeds of crime, in this case being money laundering, they can attach it. And this, as we will see in JSW Steels when we talk about it, we will see how these provisional attachments are causing greater harms to, let's say, an asset which is under IBC, or to assets which were never part of the proceeds of crime but have been, without application of mind, attached as far as Section 5 is concerned. I'll just very quickly read this part. Section 5 of the PMLA provides that a director or another officer not below the rank of a deputy director, as appointed under the PMLA, has the power to provisionally attach a person's property if they have reason to believe that the person is in possession of proceeds of any crime, and that such proceeds are likely to be dealt with in any manner which may result in frustrating any proceedings under the PMLA. So, like I said, an attachment order can be, passed, which could be, if they have a reason to believe that there is, there is a possibility that this asset was as a result of proceeds of any crime. Now, this is important also because when we look at Section 5, there is a specific definition which is given of who could, attach the property. Now, if you read Section 5, it says director or any other officer not below the rank of deputy director So there is a case where Punjab and Haryana High Court has very clearly indicated that any attachment which is done by someone who is of a rank below than the director and a deputy director, they will then, that entire attachment will go away, because there will be an illegality as far as law is concerned, because it will be bad in law. If somebody other than the rank of director or deputy director, I'm repeating this again because this is very important. A lot of times when we are arguing matters as far as attachment is concerned, you have to see if because these are intricate things, and sometimes one ignores it, and one doesn't realize that these are the most important points which can then help you as far as getting a provisional attachment lifted is concerned. So I feel that this section 5 specifically, in any case, if this is more from a practicing lawyer's perspective, but if you ever get a matter which is of attachment, do look at section 5 first. See if the attachment order is in compliance with what section 5 of the PMLA lays down. Now, this is in continuation to that. After duly conducting the adjudication process and hearing any aggrieved parties, the adjudicating authority can confirm the attachment. The question that arises is what happens when secured lenders have rights on the same property. Now, this second part I will actually discuss a little later, also specifically as far as JSW is concerned, but let me come again on the first part. When we have an attachment order, or where we see that there is a section 17 or 1 which is coming into play, you have to ensure that section 17(4), which says that within 30 days of a show cause notice being there, the within 30 days it should be adjudicated by the adjudicating authority. If that is not done, then that will be considered to be bad in law, and that the attachment or the order of freezing of account, for instance, will then be bad in law. So any application of 17(4) has to be filed, and as far as 17(4) application is concerned, it has to be filed before the adjudicating authority, who has to then adjudicate upon that specific application. Within 30 days this should be done. If it is not done, then your attachment has to automatically be considered as bad in law. This was held in Sudeep Kaur Sahani case. I can share the case details later on over here. Now, this was primarily about, let's say, as far as 17(4) is concerned, but also about the second part, as far as secured lenders are concerned. We've seen that happen a lot of times, especially, for instance, PMLA or ED related, the procedures which are followed. One will also notice that so many times, that gets countered by SURFACE Act, because there may be a possibility that the ED or under PMLA may have attached may have had a provisional attachment rather of an asset where already SURFACE proceedings were going on. So this judgment, I believe, is extremely important. Indian Bank versus Government of India, Ministry of Finance, where Madras High Court had observed that PMLA does not take into the account the plight of victims of crime, and this is happening quite a bit, and we are noticing this in so many matters. I mean, for instance, Yes Bank only, if you look at it, there was a phase where last year in February or March, I believe, where the accounts of account holders were frozen because they could only share some 50,000, they could only withdraw some 50,000 rupees. Now, this is what is happening to the victims of the crime. It is not the perpetrator who then gets punished more often. It is always the victims. So, noting the intent of the PMLA, the court held that this lacuna in the PMLA cannot result in the banks being left high and dry, and the court allowed the bank to maintain its claim under the SURFACE Act, even though the property had been provisionally attached. So that claim does not really go away. It still is there, even though there is a provisional attachment order, because that attachment order will be adjudicated and a final understanding will come as to whether or not that that particular attachment was as a result of proceeds of crime or not. Now, similarly, this case was also very important, which is called as Chief Manager Syndicate Bank versus Deputy Director PMLA. Now, the appellate tribunal under the PMLA upheld the order confirming the provisional attachment and held that the bank would have another opportunity to prove its case during the course of confiscation proceedings. This matter was very interesting as far as if you look at the intricacies of it was concerned. But at the end of the day, PMLA adjudicating authority has been talking about PMLA prevailing over every other act. We will, when we talk about JSW Steels, we will see how this conflict is brought for and how the Honorable NCLAT has adjudicated upon this conflict that happens between a secured creditor or an IBC proceeding and a PMLA proceeding parallelly taking place. Now, coming to section 5.4 of the PMLA, it states that provisional attachment shall not prevent the person interested in the enjoyment of the immovable property attached from such enjoyment. And the Indian Bank case suggests that banks will have a right to challenge such provisional attachment and claim their rights. However, from the PMLA's subsequent provisions and their interpretation by the judiciary, it is clear that such enjoyment is subject to subsequent confiscation of the property under Section 9 of the PMLA. Now, this is where I think for all the practitioners, it is important that we understand what is the difference between Section 5 and Section 9 of the PMLA. Because when you look at a plain reading itself of Section 5 and Section 9 gives you a very good understanding of where what exactly is confiscation. I would actually want to read the entire section, but I think it will be difficult for anyone to understand exactly what Section 9 looks like. But primarily, anybody who wants to practice under PMLA, one thing which is of a lot of importance is always looking at Section 5, then of course Section 8 and Section 9. As a matter of fact, the entire chapter 3 is very important, and I would want everyone to make a note of it, that chapter 3 is very important as far as attachment of a property is concerned or adjudication is concerned. And very interestingly, whatever is the reading, a plain reading of the section, that gives you a very good understanding, and you can find out areas where the lacuna lies as far as an order or a provisional attachment order is concerned, and how you would want it to be fought out as far as adjudicating authority is concerned. Now, this one happens to be a very recent judgment. It was this year only, when this was primarily about property acquired prior to the commission of criminal activity, which cannot be attached under PMLA. Now, this, I think, anybody who's practicing as far as PMLA is concerned, one would have always come across these matters, because what, in my experience, at least what I've seen is that when PMLA is sending an attachment order, they will find out all the asset that one owes, and then they will start sending attachment orders against everybody, against every asset which is there. Now, so many times, at least 90% of the times, you will see that these are blanket attachment orders without application of mind, where these assets have never been bought because of the proceeds of crime. As a matter of fact, I can cite one of the matters that I'm doing, where where my client has a property from before joining the place where PMLA accusations have come in, and that happens to be his ancestral property, and that also has been attached. So how is it that without application of mind you can attach anything and everything? So here, Punjab and Haryana High Court, and you would find a lot of good judgments actually coming from Punjab and Haryana High Court as far as PMLA is concerned, where it was held that the properties involved in appeals were purchased in 1991 and 2012 respectively, whereas the alleged scheduled offense was committed in February and March 2013. Thus, the property in question could not be treated or declared as proceeds of crime. So, this is, I think, one of the good arguments that we always take as far as, when the property is attached, which we believe, we have reasons to believe that that it was not part of proceeds of crime, but something which was brought many years back before a specific money laundering act had taken place. Now, coming to confiscation and vesting, Section 9 of the PMLA states that when an order of confiscation has been made under Section 8.5 of the PMLA, this is Section 8, if you would remember, is about adjudication. All rights and the title in such property shall vest absolutely in the central government, free from all encumbrances. Now, this, I think, is Section 9 is always what is considered to be very detrimental. As a matter of fact, I was told about a story that ED had actually bought about a Santro car, which was many years back, and all of us know that Santro does not really have too much of value. But they bought it, the ED officials, and then because it is supposed to be valued at 3x, so there was an X valuation which was done. Now, what is ED going to do out of the confiscation of a Santro car is something that is for all of us to see. But these are little things that we've been noticing that, of course, it vests with the central government, but confiscating things or confiscating assets which are not worthy of it is only, it looks like that it is only a process that they are trying to misuse instead of making it any good. When you look at the practical aspect of implementation of a PMLA. Coming back to Section 9, however, the proviso to Section 9 states that if the adjudicating authority is of the opinion that any encumbrance on the property or leasehold interest has been created with a view to defeat the provisions of Chapter 5 of the PMLA, it may, by order, declare such encumbrance or leasehold interest to be void, and thereupon the aforesaid property shall vest in the central government free from such encumbrances or leasehold interest. Now, this is a very popular argument as far as Section 9 is concerned, that the the PMLA or the prosecution typically has saying that, if like I'll just quote this, that it may by order declare such encumbrance or leasehold interest to be void, and thereupon the aforesaid property shall vest in the central government. Now, vesting of such property in central government is, like I said, is not doing a lot of good, because we are seeing that so many of these properties actually have encumbrances which are attached to it, as a result of which we've seen that a lot of financial creditors then have they would then have their NPAs which are increasing. So when we are looking at a specific act or a specific law trying to come and rescue the citizens from a certain bad act, at the same time these laws are also causing problems which are then manifesting in a different manner. I think this is where maybe the lawmakers have to look at how they can reduce this manifestation of problems which is happening. And I will come to JSW Steels, and I think that will be a very interesting discussion that we will have. But coming back to Section 9 and of course Section 8, based on the above, it may be inferred that the adjudicating authority also has the power to hear an aggrieved person under Section 8.2, which will include a lender and determine whether it has a valid interest over the property. And this happens typically, but I think PMLA the adjudicating authority also looks at all these assets from a perspective that in no manner any proceed of crime should go out of it. So one would always have a suspicion which is around any such aggrieved person who suddenly pops up and says that, I was a lender and I have valid interest against a property. Now, a lender would therefore have the option of proving the bona fides of its transaction before the adjudicating authority. And in such a situation, a lender may not have any right to the impugned property, but only have a contractual right of recourse. Like I said, that it is of course with suspicion that that the adjudicating authority will see, will look at this lender, and of course the bona fides will have to be proven. And very interestingly, this will then have contractual, the lender will only have contractual rights then, contractual rights which will flow to the lender. Whereas, like I said, the property will, with being encumbrance free, will actually go to the central government, and the rights will vest with the central government. Now, coming to third party rights in the attached property, this is one of the biggest concern, and I think 60-70% of the litigation that we see actually happens as far as third party rights are concerned. Now, you would see in any attachment, mostly there is some kind of a third party right which is there. So the issue of bona fide third party claiming legal rights over the attached property by ED under PMLA came up before the Delhi High Court in Deputy Director, Department of Enforcement, Delhi versus Axis Bank and others, whereby it held that an order of attachment under PMLA is not illegal per se. If a secured creditor has no charge on the property under RDBA and SARFAESI Act, however, mere attachment of property under PMLA does not is ipso facto render illegal a prior charge or encumbrance of a secured creditor. Now here, what is also of importance is to note that, the charge, when you're creating a specific charge, so many times a charge remains unregistered. So if my recommendation is always that, if there is a charge that is to be created, it should always be registered, because be it IBC proceedings or Company Act proceeding or PMLA, you will see that the registered charge will always be providing you a legal remedy. A lot of times people just have charge which is created, which is not registered. I feel that always creates a problem, specifically in the eyes of law. Now, like I said, that and I will reiterate this part, which is that mere attachment of property under PMLA will not render illegal a prior charge or an encumbrance which is created by a secured creditor. Now, this is a specific question which I think the long and short of the entire chapter 3 actually comes down to this, which is another moot issue in such situations is whether after approval of a resolution plan under IBC, is it open for ED to attach assets of corporate debtor on ground of money laundering by promoters, directors, or employees. So we come to JSW Steel here, but I am not going to deliberate so much on this just now. This is something that Vijayatri and I will be talking about in the end of our session. Moving on, property with non-offenders. If, let's say, for instance, I am an offender as far as PMLA is concerned, and I have a specific property which is with, let's say, my sister who's not an offender, then what is the rights which percolate out of it? Property with non-offenders, it's very clear that sections 8, 2 and 9 of the PMLA were challenged in the case of B. Ram Raju, and Andhra Pradesh High Court upheld their constitutionality. It says, it observed that in view of the fact that targeting the proceeds of crime and providing for attachment and confiscation of the proceeds of crime is conceived to be the appropriate legislative strategy. This is the intent of the legislature, as we've seen. We are not persuaded to the view that attachment and confiscation of property constituting proceeds of crime in the possession of a person not accused or charged of an offense under Section 3 constitutes an arbitrary or unconstitutional legislative prescription. So it is very clear, and I think this judgment, specifically this operative part, very clearly mandates about confiscation as far as non-offender is concerned. Now, this is basically a specific sort of a chart that we've made to make it clear as far as money laundering is concerned. You would see that provisional attachment is under section 5.1, freezing of property is under 17.1a, and seizure of proceeds of crimes is section 17.1 and 18.1. Now, if you would look at this, the first one here, as far as seizure of proceeds of crime is concerned, the complaint by the ED goes to the adjudicating authority for retention or continuation in case of seized or frozen property. So a lot of times seized property could include a laptop or a mobile phone, or could include frozen property. For instance, it could be a bank account which could be frozen. Now, either the property is released, which is section 8253. So basically section 8 clause 2, like we talked about, it is the adjudication part of it. But what really is the procedure in practical is that the adjudicating authority first confirms the attachment or the seizure or freezing, whatever is the case, under section 8.3, which is the adjudication thing. Now, then there is an appeal which lies to the appellate tribunal by aggrieved within 45 days, which is section 26.3. This maybe we can discuss in a separate talk, because appellate and prosecution actually happens to be a different ball game altogether. Here we are only looking at what happens as far as adjudicating authority is concerned. Then appellate tribunal confirms or set aside the order, and appeal to High Court can be filed within 60 days. This is given in section 45. This is just a very a simple snapshot which is given over here, but it is typically, you would see, it does not really adhere to the specific timelines which are given. So we've just finished this part. I will just stop the screen sharing, and then maybe Bijayatri can come in and we can talk about JSW.
Yeah, Pallavi, the presentation was really interesting. Thank you for that. Now, going back to my question on the case. So, I would just like to have a brief view on the case from your end as to like how it is related to our topic for discussion today, and what do we, what should we really look into while we are probably, analyzing or reading that particular case, and how
So,
it's relevant.
yeah, I think we actually discussed about JSW Steels also, and I think
Mhm.
what had happened was, and this is very interesting, is that JSW Steels, there was a case which was filed and it went to NCLAT, where the ED had attached the property of the corporate debtor. Now, if the property of the corporate debtor is attached and there is a resolution plan which has already been, uh, finalized as far as the CIRP process is concerned, once a resolution plan is finalized, then what happens is that the successful resolution applicant is going to send that money to the resolution, the corporate debtor's account. Now, if the entire property gets seized of the corporate debtor, then what remains? What will the resolution applicant then work upon? One, and secondly, how is it that we've always envisioned IBC to be a very time bound proceeding, and we've always understood that IBC is basically there to come and rescue companies which have really lost their path. So for that to happen, it was important that everything was time bound, one, and secondly, it should be hurdle free. But there was definitely a doubt which comes into the mind of people that maybe, companies would deliberately go under IBC, and some related party would probably come rescue them, and that all the proceeds will then go back to the offender who was there, being, let's say, for instance, the promoter of the corporate debtor. So this has always been there in the mind, in the back of the mind, as far as IBC proceedings were concerned. And we've seen Justice Nariman actually giving some wonderful judgments as far as SR was concerned. I think especially, the new metal and all of these were, I think, very important judgments that came. Now, this goes before NCLAT, and the NCLAT says that there are two different submissions that I'm seeing. One I'm seeing is from Ministry of Corporate Affairs, who says that no, IBC is very good and IBC should prevail, and there is Section 230 which provides for prevalence of IBC having overriding effect over every other law which is there in the country. That is agreed. Then comes ED, and ED says that no, I am going to confiscate because this is all proceeds of crime, and therefore I am the one who should be confiscating these in order to keep it with me, because ultimately the asset lies with the central government. So there was this conflict which was there, and just before Justice Mukhopadhyay, so Justice Mukhopadhyay says, okay, fine, you decide amongst yourselves and you tell me whose submissions will prevail. So while this matter was going on, finally the government last year then brought about an amendment to IBC, and where they said in Section 32(1)(a) that IBC proceedings will of course prevail. And interestingly, they also said that I will just point out that specific paragraph because I really like that paragraph. But they say that, and this I'm quoting, insofar as corporate debtor or its assets are concerned, after the completion of CIRP, a statutory process under the IBC, there cannot be any attachment or confiscation of the assets of corporate debtor by any enforcement agencies after approval of resolution plan. So now the criteria was very clear that if the resolution plan has been approved, then there cannot be any attachment of the corporate debtor. You want to attach, go attach the promoter or any employee who has been found to be guilty as far as PMLA is concerned. But you cannot attach the properties of the corporate debtor. So this was one very important step forward, which is given as far as the judgment is also concerned. Then what happened was that then ED comes back and says that no, this ordinance, even though it has come, I say that this is all prospective in nature. There's nothing which is retrospective. Now there was another Pandora's box that is opened up where people are thinking, now what do you do? Because most of the resolution plans were actually approved as far as 2019 was concerned. Everything was approved from before. So then Justice Mukhopadhyay has written a very interesting paragraph. I'll just quote that. I'm sorry, I'm taking so much time, but this is paragraph 45, page 50 of the NCLAT order. He says, Union of India had unequivocally stated that after the completion of CIRP, there cannot be any threat of criminal proceedings against the corporate debtor or attachment or confiscation of its assets by an investigating agency after approval of resolution plan. This is something that I just quoted. In any event, by virtue of Section 238 of IBC, which has, the IBC has an overriding effect over anything inconsistent therewith in any other law. Accordingly, it is clear that subsequent promulgation of the ordinance is merely a clarification in this respect. And therefore, it is expressly evident that the ordinance, being clarificatory in nature, must be applicable retrospectively. And he defines it. And this, I think, is the long and short of the entire JSW Steel's argument. Even though the appeals have been filed before the Honorable Supreme Court and it is still pending before the Honorable Chief Justice of India, there is no such stay which is operating just now. At least in my knowledge, I don't think that there is a stay. There were some provisional attachment orders which were also stayed at that point in time, and I think the stay continues. They are going to be listening this matter finally in January, middle of January. So I think we will have a clarity. But this is very clear that there was an intent by the government, but two different departments of the government itself are fighting over which prevails over which. So I think this was one part that I wanted to add as far as JSW Steel was concerned. And I think anybody who's a practicing PMLA advocate should definitely find JSW Steel and rely upon it as much as possible.
Okay. I think we can start taking the questions, right?
Sure, please go ahead.
All right. Now, the first question is from Naman. Uh, okay, so the question is that his background is MBA in finance, and he plans on having a career in international anti-money laundering work, for example, at FATF, UN, or at the national level. So, what qualifications or expertise can he build upon in the next few years? And he would like some guidance from you on that.
Okay, this is very interesting question, but I see that you are an MBA in finance. But is it that you want to go into the litigation of PMLA? This is not clear. I mean, then if you want to go into the litigation side of it, then you will probably have to get a law degree for yourself. Because I will only be able to give you an understanding as far as litigation is concerned. And my first guidance would be that you get yourself an LLB, because I think it's not just well, actually the economic international finance side of it. Well, then I think there are many courses which are given. I'm not very sure about which colleges abroad have these courses, but because money laundering is something which, like I said, is spread over continents just now, there are too many there are many colleges, at least abroad, I know of, where I would not know the names of them, but I know of people who've got these their specializations which have been done into money laundering. However, if you are specifically looking at litigation, then getting a law degree is a good idea, or MBA in finance if you've done. You will see the application of MBA finance, because I also happen to be an MBA finance. I don't see so much of an application of an MBA finance as far as this is concerned, but more application of being a law graduate, which brings about support as far as these kind of matters are concerned.
Okay. Now, another question is, if any property is sold based on forgery, then will the complaint be filed with the police and ED? Will both the properties, that is the property which is sold off and the property being purchased by the seller, be confiscated?
So the as far as forgery is concerned, how can you go before ED? At least in my opinion, it is not the ED which is there, unless you have something to show that this this property was as a result of proceeds of crime. The complaint will definitely lie before police, and that is where you will have to go as far as forgery is concerned. Now, and you will find a proper adjudication before the police instead of ED, because ED already is overwhelmed with the number of matters that they are doing. However, if you can prove that there is definitely, there are, there is evidence which shows that there is probably this person has been involved as far as money laundering is concerned, then you can go ahead and file a complaint. But interesting, since it will be part of, it will be proceeds of forgery. So forgery and money laundering are actually very different crimes here. So if you see that it is proceeds of PMLA, money laundering, then definitely go ahead and file a complaint before ED. The ED will take it forward. But I doubt that that will actually work for you, because forgery, if something like forgery is happening, then how is money laundering involved? You will have to make a very good case out of it for the complaint to take a possible for a complaint to convert into an investigation. Also, I don't know how many of you know this, but one of the big cases which is going on just now, the complainant himself has now become an offender, because he filed a complaint before the ED, and now he is, of course, one of the accused persons in the matter. So always be treading with caution, I would suggest.
Yeah, especially in these kind of matters.
Correct. Yeah.
Okay, now we have another question from Sunil. Though the question is not really clear to me, I think Pallavi will be able to understand. If reason to believe to issue the notice for attachment turned out not being a reason and subsequently the offender proved, then what will the ED
Attachment
do?
order will go away. It is bad in law. You will get an order in your favor, and that attachment will go away. This is happening a lot of times, by the way, and there are so many times adjudicating authority. If you are not getting an order from the adjudicating authority, you go in and appeal. You will find that the appellate tribunal will definitely, if there are specific, you are able to show that there is no reason to believe as far as the proceeds of crime and attaching of property is concerned, please by all means go before the adjudicating authority. And if there is any dismissal order that comes, then please go before the appellate tribunal. You will get yourself an order which will come in your favor. This is happening so many times because, we also have to understand that the investigating agencies probably overwork with so many matters. So for them it is probably that, these 10 assets I can see and I'm going to freeze those 10 assets. Then it is upon us to prove that no, out of these 10 assets, maybe two of them you can think of as being part of proceeds of crime, but the rest of the eight are actually not. And this is for us to bring about that there was no application of mind which was used when the attachment was being done. I hope that answers your question, Sunil.
Okay. So I think we don't have any more questions. So I'll just quickly share my screen and I'll take you on a virtual tour to EVC Learning's
I'm
website.
super excited about it, Vijay.
Yeah. Um, so, I guess the screen is visible, right?
Yes, it is.
All right. So this is for everyone and also for Pallavi. This is EBC Learning's website. So it's ebclearning.com. And all you need to do is if you want to obviously access all the courses. So we have over 50 courses and interviews, panel discussions, etc. And also we have all the previous webinars also. All of them are here in this. So all you need to do is you need to take a subscription. And of course, if you have subscription, you can just log in with your ID. And basically, if you scroll down, you'll find that we have a list of upcoming courses and talks. So right now we have these in our upcoming courses and talks. Plus, we have a number of courses which are already released. We have some new releases right now. One of them is from your field, Pallavi. It's about AOR exams. So cracking the AOR exams. Then we
Navita.
have, yeah. Then we have uh, an interesting course on building e-commerce from the legal perspective. Then we have,
E-commerce is very important considering
yes,
the Consumer Protection Act.
yes, mm,
E-commerce has become a huge. Yesterday, the day before only, there was a matter which was going on before Supreme Court, and I think it was very important that a lot of people do not even know that they are not e-commerce compliant. So I think this will be
yeah.
a good course for all the lawyers.
Yeah,
Yes.
so we have this course plus related to that, like you said, consumer protection laws. So we have two courses on consumer protection laws as well. So one is the basics of consumer protection, the other is the practice and procedure. So it's by the same person, Dr. Pratima Narayan.
Right.
Then we have a very interesting new course which is on legal research and writing. I think, especially if any law students are watching this particular webinar, you should actually go for at least try to, go through this entire course because it's going to be really helpful for them. Plus, of course, we have contract law essentials. So the first module has already released, which is on formation of contract, and in the upcoming we have a few more modules for that also coming up. Apart from that, there are some other courses also which are generally interesting and are going to be useful for law students, professionals. So one is contract drafting, the other is arbitration, then essential skills for legal profession, mergers and acquisitions. So basically, we have almost around a collection of 50 and up courses and talks which people can view on our website. The only thing is that you need to subscribe, and that's it. And another thing is that all those who have not subscribed to our YouTube channel, please go forward and do it. And the YouTube channel will, of course, you'll be able to find our previous recordings of webinars. Plus, this particular webinar, like I said, it was live, and obviously after this also it will be available. So anyone who has missed any part of the webinar can, of course, go back to it and watch the webinar recording. So thank you very much, Pallavi.
Thank you, Vijetri, for having me here. I'm so happy to that, finally we actually got to do a session which was not on insolvency.
Yes, exactly. So, and it was a very interesting session in the sense that, like all these new cases and all these new discussions that are going on about PMLA, about money laundering, then about what actually should be the role of the officials, where do they sort of trespass the responsibilities of the other authorities. So in that sense, plus in the sense that there definitely has been a lot of confusion about these terms that are used in PMLA, especially when we talk about attachment and then confiscation. So there's a lot of confusion about that, and I'm really glad that you did this session. You explained these basic terms. Plus, it was a really nice participation by our attendees today with all these interesting questions that came up. So, thank you everyone for joining us today for this webinar. And thank you, Pallavi, once again.
Thank you.
Um, yeah. So, I'll just log out.
Thank you.
Thank you.
Thank you.
Thank you.